Okay, we covered 4 topics in the first video for chapter 7. We're going to cover 3 more here. Hopefully get to the questions at the end of the chapter. If not, I'll create a 3rd video. Okay, the next area I want to get into is a really interesting one, and California has voted on this in the past through the initiative, the ballot initiative process, and that is called joint and several liability. There's a lot of variations on a theme here as you read it in the chapter, but the basic idea is, what if there are multiple defendants? When an asbestos suit is filed, I have seen the initial complaint on a case, and there may be 50 defendants involved, because the plaintiff attorneys are trying to figure out any manufacturer of an asbestos-containing product that the plaintiff may have been exposed to. Along the way in the litigation, a number of the defendants, most of them will get dismissed, because after further discovery and fact-finding, you will determine that, in fact, it's unlikely that a certain company's product was being utilized by the plaintiff. But the question here is, can you sue all of them for losses? And if they are jointly together and severally, individually liable, you can do that. Strategically, you go after the deep pocket. So if they're all going to be held responsible or responsible to a degree, you're going after the one who can most likely fund a settlement or pay a judgment. Now, this seems to be inherently inefficient, because you may actually, if you can collect against a bunch of different parties, maybe you can end up collecting more than 100% of a judgment, okay? And that may be perverse, because it may lead you to want to get harmed to a degree, because $100,000 in damage may lead to $300,000 in potential recovery, okay? And that's clearly not efficient. As it turns out, the common law identifies 2 circumstances where this is okay. Number 1, where the defendants acted together, so you can't parse out who did what. And the harm itself is indivisible. So we know they were exposed to 5 firms' products, and there's no way of knowing which exposure was stronger than whose ever, and which is the item that caused the disease. Okay, so there you are able to sue against multiple parties, but recognizing that there is this risk of more than 100% recovery, which would lead to a dramatic increase in litigation. Legislation has evolved over time. So in many of these cases, and it's actually happened in some of my asbestos cases, defendants have what is known as a right of contribution. And what a right of contribution means is, when you set a settlement by one party can offset the remaining liability of other parties. So it becomes a very valuable strategic skill to be able to settle cases with multiple defendants, and particularly kind of map out, okay, I'll settle with the small fry first and only go after the big ones that may be able to really fund a big award, because there's already going to be an offset right off the bat. Let me give you an example. Let's say you've got an asbestos case and there's $1 million in economic losses between medical expenses, future medical expenses, and the other damages suffered by the parties. It could be the plaintiff, their spouse, loss of earnings, household services, stuff like that. If they have settled already for $250,000, then the most left to receive any award is $750,000. That's the most you can collect, okay? Sometimes the contribution works in a different way, because I had a case a number of years ago down in San Diego, and my client said something to me to the effect of as follows: we've already settled with several parties, so we're not going to get a dime unless we get more than $1 million in damages. So in other words, the contribution is from $1 up to a certain level. And so if the jury came in and said, we're going to award $1 million, they're not going to get anything, because they already collected the $1 million. So it's not like some of it goes against the defendant that goes to trial, and then there's an adjustment against those that are already settled out. Not at all. Right? At some level, this kind of is appealing because, number one, it gives you an encouragement to settle. Certainly gives the defense an incentive to settle. And it does limit the amount of rewards so you don't get to some sort of perverse incentive of wanting to litigate simply because you could really make a windfall in that particular case. Okay, application number 6, medical malpractice. Okay, we're very familiar with medical malpractice cases. We've talked about it before. Statistics seem to show that medical errors cause upwards of 100,000 deaths a year. There was a study back in New York a number of years ago. 1% of admissions led to an injury due to negligent care. That's pretty bad. Okay. But we have restrictions. Why is a medical malpractice any different than any other tort? Okay. It still involves negligence. We're still looking at economic damages, but here are the things that are different, okay? An initiative passed, it may have been by the legislature, and I think through the ballot process, there have been attempts to overturn it, but it has not been successful to overturn it so far. And that is, in response to, in the 70s and 80s, some very big verdicts, because jurors can be all over the map. We know that. Okay, you could have 2 cases with identical sets of facts. It's up to the subjective opinion of the jury as to how they're going to evaluate that. We talked in Chapter 6 about some courthouses that are really tough on plaintiffs and some that are really generous to plaintiffs. And given that periodically there were vast multi-million dollar awards in malpractice cases, particularly involving births going against OBGYNs, that the concern about the increase in insurance premia to cover doctors in certain specialties like those delivering babies led to higher medical costs or an absolute reluctance to practice. And so a number of states passed rules. California is amongst the most restrictive. You think of California as a liberal state. It's amongst the most restrictive with regards to medical malpractice. And they put in a limit of $250,000, I think it was in the late 70s, $250,000 as the non-economic damage award cap, meaning anything relating to pain and suffering in medical malpractice cases limited to $250,000. Maybe you could get it for multiple parties in the case, but even that's kind of difficult. So what that does is obviously reduce the potential upside in an award. It discourages the filing of lawsuits unless you could establish significant economic damages, because those economic specials, as they call them, will get tacked on to the $250,000. So here's the deal. If you get a retiree who is butchered by the doctor, lawyers are not going to be very willing to take the case because they know, and they've said it flat out to me, I'm going to spend a ton of money on experts. I'll spend 50 grand on experts. If I get a grand slam home run, I'm going to get 200, whatever the jury awards, it's going to be knocked down to 250,000 max. And that's under the absolute best of circumstances. So unless you've got a demonstrated loss of earnings or significant future medical expenses. So for example, where there's something that happens in childbirth, very unfortunate cases, but the child's going to need maybe tens of millions of dollars of care going forward, those kinds of cases they will take. If you have something that the doctor's really messed up, let's say there's a disfigurement, but there's no loss of earnings in terms of the ability of the young person to be able to, pursue whatever career they want in the future. And you don't have ongoing medical treatment that's significant because the disfigurement took place and that's it, then attorneys are not going to want to take those cases. So I have talked to lawyers and actually presented them with cases involving people I know where the medical malpractice of the doctor being negligent in what they did, not following a standard, are clear, but they don't want to take the case. There's not enough in it for them to be willing to do it. Because remember, $250 is an award, minus, let's say, paying 50 grand on experts, gives you 200,000, and they get their fee based on that. So the amount of money they're going to make from it, under the best of circumstances, not that great. And medical malpractice cases are very hard to win. It's up to the subjective determination of the jury, and whether something was medically negligent or not, you'll always find a medical expert who's going to say it was within the standard of care, and you'll get another one who's going to say it's not within the standard of care. And jurors tend to still be pretty favorable on average to doctors in situations like that. Okay, now, look, it obviously maybe reduces the cost of providing medical services. It certainly increases the amount of precaution that would be taken by the victims. To avoid medical malpractice, doctors, we know, have practiced defensive medicine. They incur maybe unnecessary expenses to run more tests to simply cover their butt, that they don't get sued. So it's kind of a mess. There's no easy answer, because jurors can be persuaded by someone who's very effective in the courtroom, and these very big awards, may be without limit. Florida, as an example, a state that's usually considered to be pretty conservative, the non-economic damages are limited, or up to $1 million. There have been attempts to increase it. I think in November there's going to be another attempt at the ballot box to increase it, but it's going to be a tough one. Okay, we're going to finish with toxic torts and do the questions in part 3.